This request has been made before. I examined it, but just so there would be no question, we had our outside expert, Mr. R. Bartley Halloran, examine it. We presented our opinion to the RTM, and our opinion was that there was not a basis
Excuse me, I'm sorry, I had to move these for the camera, I didn't want to interrupt you.
to sue Wigan and Dana for malpractice. There was no basis to show that they breached the standard of care. We also looked at all the other lawyers, McCarter and English, Updike, Kelly, as well as the Marcus firm. The recommendation we received from our outside expert lawyers was to sue the Marcus firm, and that's what the town did. That's the first question. In the appeal that we filed, one of the issues was a challenge to a jury instruction. What's important to know, in the appellate process, you cannot challenge a finding of the jury. You can challenge the legal basis upon which they acted. In our appeal, the town claimed that the trial court was in error when it instructed the jury as follows. The court instructed the jury that to prove that the town acted in bad faith and violated their rights under the takings clause of the Fifth Amendment, the plaintiffs must prove by a preponderance of the evidence that as to each of the three reasons that the town of Branford has asserted for its use of eminent domain, that either, and let me emphasize that, the word is either, one, the town's stated reason was pretextual and its actual reason was invalid, or, not and, or, the town acted unreasonably. Now, under the law, unreasonableness is a difference of opinion. Negligence. I didn't see in any of the listing here that Mr. Cook put out this phrase. Or three, the town abused its power. At trial, Attorney Callahan, on behalf of Updike Kelly, properly took exception to that charge as being not the law. Then there was an interrogatory or a question given to the jury. And the court asked in that interrogatory the jury to answer whether the takings clause was violated because each of the town's three reasons offered for the taking was, once again, either pretextual and invalid, or unreasonable, or abuse of power. The jury answered yes. We don't know, based on the jury's decision, what it decided, whether it was all of them, some of them, or one of them. There was no finding by the jury of dishonesty, unless dishonesty means pretextual and its actual reason was invalid. We don't know if that's what the jury found. We asked the Supreme Court to consider this very important issue. For some reason, they did not decide that issue. We are, on behalf of the town, looking at this question to see what it means. And we'll provide further advice to the town about that. Now, as to the specific issue of pretext, the important stated reason, according to the Supreme Court, was to investigate and remediate possible contamination. Because the town was precluded by the court from introducing any evidence about that, the jury had no evidence before it by which it could make any assessment of the town's stated reason. There's a lot of discussion in the decision about what New England Estate said and what the owners said. But there's no discussion of what the town's experts would have said about investigating and remediating contamination. Now, when a presentation was made to the RTM, and this is public record, it's on discs, counsel for the town at the time advised the RTM, in conjunction with settlement discussions, that experts had been retained, were prepared, and would testify at trial. As you all know, neither Attorney Reif from McCarter English in the valuation case or Attorney Callahan in the civil rights case were able to present any evidence because the deadline to disclose the experts was missing. Judge said, "Town, you cannot explain to me in one case, you cannot explain to me or the jury in the other case why you felt you needed to investigate and remediate the potential contamination." So as we sit here now, and that in large part is the basis for the malpractice action, as you know, because I've briefed you on that before. But as we sit here, the critical issue that Mr. Cook is raising here, and I understand he's not a lawyer, he's a layperson, I'm not trying to be critical, but I'm trying to look at this analytically. We raised the issue, we presented the issue to the Supreme Court, we asked them to decide that because we're entitled to know. Are you saying that we were unreasonable? Are you saying that we abused power? Or are you saying that we engaged in pretext? That question was never answered by the jury. They simply said yes to a series of ors. Now, I know that's fairly technical, but it's actually very important. So, from that narrow finding of the court, the jury, all of this discussion of dishonesty arises. But in searching the decision and the record, there is no such finding other than what I just read to you, and that is a fair statement. I'm somewhat perplexed by what the court did. I'm trying to understand it so that I can advise you further. But those are the facts that are presented to us. Those are the legal issues. We're obviously disappointed that the court didn't decide it. We don't know why, whether it was an oversight or whatever, because Justice McLaughlin was obviously very careful to go through multiple arguments of multiple parties. But based on the decision as